Hi, I'm attorney J. Scott Smith, and now that it's summertime in the Tar Heel State, a lot of folks are out in the lake having fun, and in many cases mixing that fun with alcohol, which segues into the topic of this video. I want to talk to you about boating while impaired, or BWI in North Carolina. Technically, I guess it's OWI for operating while intoxicated if you look at the statute. OWI, or operating while intoxicated, is actually what's referred to in North Carolina General Statute section 75A-10. A lot of lawyers go into these cases presuming that they're just DWI cases on a boat, but that couldn't be further from the truth. There are many differences between a DWI and a BWI in North Carolina, and in this video series we'll discuss just what they are and why it's important to know how these two crimes differ. Some of the main differences between a BWI and a DWI involve the following: punishments, license revocations, field sobriety testing, and more. While the National Highway Traffic Safety Administration, or NHTSA, has their own tests, the National Association of State Boating Law Administrators, or NASBLA, has theirs too. This video is meant to be an introduction to our video series on BWI in North Carolina. The videos that follow will go into more detail on each topic we cover. As an overview, there are 3 phases of investigation in a typical BWI contact. Phase 1 is called vessel in motion. In this phase, the officer sees the vessel in the water and has to make a stop or no stop decision. In many states, the officer must show some reason to pull over the vessel. The officer, usually wildlife enforcement, needs no reason at all to board your boat. Merely checking to see if you have the proper number of life jackets is sufficient. But we'll go into more detail on that in another video. Phase 2 is personal contact. This occurs after the officer's boarded your boat. In this phase, officers look for some of the same things they look for in a DWI case: bloodshot eyes, odor of alcohol, open containers, slurred speech, admission to drinking, and many more of the standard indicators. Phase 3 is the pre-arrest screening. This phase occurs after the initial contact, and this is where the field sobriety tests are given. While one of the standardized tests, HGN, is similar to the one given in a DWI investigation, the other tests are not. NASBLA has a 2-part test battery: the afloat test battery and the ashore test battery. The afloat test battery consists of 6 separate field sobriety tests: horizontal gaze nystagmus, or HGN, the alphabet test, the backwards count, the finger count, the palm pat, and the finger to nose test. This portion of the test was later changed to the seated battery of standardized field sobriety test, which contains only 4 tests: HGN, finger to nose, palm pat, and the added hand coordination test. The hand coordination test is a test that was adapted from the walk and turn test. The ashore battery consists of the same test used in the DWI investigation: HGN, walk and turn, and one-leg stand. A PBT, or portable breath test, may also come into play, as well as an actual breath test after arrest at the station. In North Carolina, you can refuse all of these tests, and you should. Even if you are convicted of BWI, it has no impact at all whatsoever on your driver's license or your ability to drive a motor vehicle. BWI, or OWI, however you want to say it, is, however, a Class 2 misdemeanor in North Carolina. In our next video in this series, we'll examine the standardized field sobriety test of the seated battery in these types of cases. Remember, arrested doesn't mean guilty.